Welcome to Gosfield and Shay on Health Law.
Hello and welcome to Gosfield and Shay on Health Law with Alice Gosfield. Alice is a nationally recognized healthcare attorney who has spent her entire legal career advising physicians on Medicare, fraud and abuse, stark law, and value-based payment. She is known for her strategic clarity, prolific writing, and deep influence on federal healthcare policy. I'm LeAnn Lyon, and today we are talking about sharing the money under Stark, including productivity formulas, profit sharing, and the compensation mistakes physician groups still make. Hello, Alice. It's great to see you.
Hi, and good to see you again.
Alice, physician groups often think internal compensation decisions are theirs alone to make. How deeply does Stark actually regulate the way money can be shared inside of a practice?
Well, first, let me say this is the single worst piece of legislation I've had anything to do with in my career of more than 5 decades. My standard line is the people who wrote it were not unduly burdened by any knowledge of the way Medicare works. The basic premise of Stark is that it's prohibited for a physician or an immediate family member to refer a Medicare or Medicaid patient, only Medicare or Medicaid, for a hit list of specific designated health services when the physician or family member has a financial relationship with the entity to which they are referring, unless the relationship fits under statutory or regulatory exceptions. Stark is a statute that you either comply with or you don't. The problem is that in determining what exceptions apply, some require that the physicians qualify as being in a group practice, which is specified in accordance with a big set of regulations, and it addresses allowing productivity payments, which is payments for the fruits of the physician's own labors, and profit sharing, which is where the physician orders a designated health service or orders the technical component of a diagnostic test that's subject to Stark. So it reaches directly into the bank accounts and wallets of physicians in their private practices in terms of how they pay themselves and each other.
Well, productivity compensation sounds straightforward until designated health services, diagnostic testing, incident to billing, or ancillary revenues enter the picture. So where do groups start getting into trouble?
The first problem is if they try to apply logic to any of this, because there's nothing logical about it. It's a series of relatively arbitrary rules that were developed in the context when the law was first enacted of the phenomenon of something called group practices without walls, which was where loosely structured networks would purport to be a group practice when they really weren't integrated as a single group practice. And so a lot of the law is oriented around not allowing that when physicians are going to make money off of designated health services, which is all imaging under Medicare and Medicaid, outpatient prescription drugs, physical therapy, occupational therapy, clinical laboratory, durable medical equipment. There's a hit list of what the designated health services are. The first issue is that this statute applies only to physicians, but that's physicians as defined in Medicare, which means MDs, DOs, dentists, podiatrists, and chiropractors for only one service. The referrals that are implicated are only for the hit list of designated health service, so you really have to know what that hit list is. And they're both in the statute and then expanded upon in the regulations. All imaging under Medicare and Medicaid is designated health services, but all diagnostic testing is not. So electrocardiograms, electroencephalograms, electromyograms, none of them is DHS under Stark. Technical components of designated health services, which is not what the physician's interpretation is, but the using of a gizmo on a patient, so to speak. The technical component revenues cannot be allocated to the ordering physician unless he literally performed the technical component himself. He put the ultrasound wand on the patient's belly and a tech was not involved in it. If a tech is involved in it, then all of the revenues of that have to float up into a profit-sharing pool and cannot be allocated to the physician who ordered them. The first settlement under Stark on internal practice compensation occurred 22 years after the law was enacted, and it was within a cardiology practice, specifically with reference to how they allocated technical component revenues for CTs and nuclear studies. Incident 2 has been part of the Medicare program since it began, and when I teach people what Incident 2 means, I say think about what medical practice looked like in 1966 when Medicare was enacted. It was usually a 1 or 2 person physician practice and the girl. And the girl was somebody who was either a VOTEC trained medical assistant. Very often it was the physician's wife. It might have been a laboratory trained technician. And in a very hotsy-totsy practice, it was an RN. But these people did everything. They took vital signs. They did EKGs. They roomed the patients. They did reception. They did transcription. And if Congress had said we're only going to pay for the physician personally laying hands on the patient, no one would have participated. So Incident 2 said we will pay for those services that are an incidental, although integral part of the physician's personal professional service to the patient. But there are specific requirements associated with Incident 2. Why does it come up in Stark? Because even though referrals for services to another person cannot be allocated to the ordering physician, the statute specifically says the physician can get direct dollar-for-dollar credit for Incident 2 services, but they have to meet the definition. First, there has to be a physician service to which the ancillary personnel services are incidental. There has to be a physician, not necessarily the treating physician, on premises and immediately available to assist while the services are being rendered. And the claim must be submitted under the number not of the guy to whom the services are incidental, who's the treating physician, but whoever the physician is who's in the office, who may not even know the patient, see the patient, or even know that he's being billed as the supervising physician. It is a referral in logical terms, but it is a permitted referral.
Wow, I can just hear your passion for this. And maybe just a bit of the sarcasm as well, which is good. But under Stark, why is the distinction between personally performed services and referral-generated revenue so important?
So revenues from personally performed services can be allocated dollar for dollar to the treating physician. It is they benefit from the fruits of their own labors. They can be paid directly for what it is they do. But if they have another person involved, if they refer even to another physician within the group, that has to be allocated either in a profit-sharing pool that the group practices in accordance with its rules, or the referred to physician may be given all of the credit for his personally performed services. There's no obligation under the law to share profits, but if you are going to share profits, there are significant restrictions about how those profits, again, only with regard to the hit list of designated health services, may be allocated.
So Stark treats productivity compensation differently from profit sharing. Why does that distinction matter so much when groups decide how to divide revenue?
So personal productivity is easy. You did it, you get the money. Profit sharing is way more complicated. You can have one pool of money. You can't do it by modality. You can't have the PT pool and the clinical lab pool and the imaging pool. All the DHS revenues that are going to be shared have to go into one profit sharing pool. But to make it more complicated, you can have within a group practice pods of at least 5 physicians who may be sharing in the profits under different formulas. One group is being paid based on their seniority. Another group is being paid based on the work RVUs of their evaluation and management services. Whatever the methodology is that's used for each of the pods, it cannot directly reflect the volume or value of the referrals that the physicians in the pod have made. That said, in a provision which strikes me as idiotic given all of the other restrictions, a pod of 5 can share within their pod all of the DHS revenues that their pod generates. So if you have a group, I've had groups of 300 physicians where there are, 15, 18 pods. If you are a group of 5 or less, you only get one formula. You can't pick and choose the formula. You don't have to allocate the profit sharing that's generated. That's not an obligation. You can decide to leave it in the practice to facilitate development of the practice. But if you're going to share profits, you have to follow these really complicated rules.
Interesting. So, what are the distinctions between the Stark statute and the anti-kickback statute?
So the Stark statute is only relevant to Medicare, and an example of why the people who wrote it were morons when it came to understanding how the federal healthcare system worked. They wrote a provision in the statute that said that no federal financial participation is available for a Medicaid service that's funded by the state and the feds together, a Medicaid service that would not be paid for if it would not be paid for under Medicare and the Stark rules. Federal financial participation is millions and millions and millions of dollars going to a state that they meet with their own revenues. There's no way to say that this particular imaging service is going to be disallowed out of the millions and millions and millions of dollars. So while there are courts that have said that the Medicaid statute does apply to this, there's no way to actually implement it. Stark is a strict liability statute. Your intentions can be as pure as the driven snow, but if you violate the law, you violate it. The anti-kickback statute applies to all federal healthcare programs. It applies to all services, not the hit list of designated services under Stark. It applies to all players up and down the food chain. And the anti-kickback statute is intent-based. It's whoever knowingly and willfully solicits, pays, offer, or receives any remuneration in cash or in kind, covertly or overtly, directly or indirectly, including kickback, bribe, or rebate for the referral of a federal patient, to induce the referral, or for ordering, providing, leasing, furnishing, recommending, arranging for the provision of any service, item, or good payable under a federal healthcare program. That's a direct quote. I can do that drunk, and I can do it in the middle of the night, and I've been tested on both.
I was going to say, I think you've said that once or twice before.
I believe I have, yes.
Impressive. So, as groups move forward towards compensation tied to quality, efficiency, or value measures, what role does Stark play?
Stark actually has regulations that were promulgated in 2020 at the end of the year that relate to value-based enterprises and value-based arrangements. This was a very new approach that looked at the issue of, if we're really going to get value, providers, including physicians, and Stark is physician only, so they're oriented around physicians specifically under the value-based rules, to incentivize them to engage in a continuum of care. The ability to be able to share revenues and profits among the players would have to be recognized. And so the value-based enterprise regulations are the Stark accommodation for these new approaches of more team-based care that involves multiple providers delivering a continuum of care to a Medicare or Medicaid patient. The anti-kickback statute also has value-based rules, but they're far broader than the Stark ones because the statute itself is far broader than Stark.
So, how should groups think about overhead, cost centers, and pods when designing compensation formulas that are both practical and defensible?
So the Stark regulations actually have very little to say about expenses, other than to say that to qualify as a group practice, the expenses have to be shared among the members of the group. Cost centers can be the focus of profit sharing. You can say, for example, we're going to have the Elm Street office as one pod and the Green Street office as another pod. And as long as there are at least 5 docs in each of those pods, you're okay. You could have 5 docs that share profits and 2 physicians in a 7-physician group that don't share profits at all. So that's also another option. You're not obligated to share all the profits. The bases on which the formulae can be constructed are fairly broad and liberal, as long as they do not directly reflect the volume or value of business. Seniority, the amount of shares that somebody owns, the work RVUs for the evaluation and management services, which is visit services that they render. There are a bunch of different things that you can use, number of patients, number of encounters, as surrogates for the volume of what it is that the physicians are doing on the designated health service side, but you can't directly reflect the volume of designated health services that they order.
So once a group has a compensation formula, how and where does it need to be documented, or should it be documented?
There are basically typically two options. One is it gets documented in the employment agreement. The problem with that is if you want to change it, which you can do on an annual basis, you can change it prospectively, you can't change it retrospectively, but then you have to change the employment agreement. So a better way of handling it is saying in the employment agreement that the employed physician must comply with any practice-wide adopted compensation formulas, and then the group adopts it as part of their ongoing, general corporate undertakings, and it gets documented in the minutes of the practice.
Okay. And as we wrap up today's episode, looking ahead, do you think Stark's compensation framework still fits the realities of modern physician practice, or are physicians trying to operate 21st century models inside of an outdated regulatory rule?
I think the detail in the statute is much too much. There's data that shows that it doesn't even work. The volume of imaging has skyrocketed, even though the Stark statute is focused around imaging. There was only one attempt to repeal it. And I always say this is the Monica Lewinsky story, because the attempt to repeal it was in the budget that Clinton vetoed when he was in his big budget fight with Newt Gingrich. And it was during the time that the government shut down because the budget had been vetoed that he got in trouble with Monica Lewinsky. So that's the connection between the Stark statute and Monica Lewinsky, which most people are unaware of. I think it's outdated, but I also think that the regulators are struggling to make it more modern, which is reflected in the value-based enterprise and value-based arrangement rules. But that's the most significant change in many, 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 many years. I'm a skeptic.
Got that. But thank you. This was incredibly informative. And to our listeners, I want to thank you as well for listening to Gosfield and Shay on Health Law with Alice Gosfield. If you'd like more information on the issues we discussed today, including Stark Law, physician compensation, Medicare compliance, and healthcare regulatory strategy, visit gosfield.com. For more guidance and thought leadership from Alice and Dan, be sure to explore the firm's publications and resources on the website. And if you enjoyed this episode, please subscribe, leave a review, and share the show with others in the healthcare community. Thank you so much, Alice. This was delightful.
Thank you, LeAnn. I enjoyed it, actually.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.